Lynch Law in America by Ida B. Wells-Barnett. This was written in 1900. Our country's national crime is lynching. It is not the creature of an hour, the sudden outburst of uncontrolled fury, or the unspeakable brutality of an insane mob. It represents the cool, calculating deliberation of intelligent people who openly avow that there is an unwritten law that justifies them in putting human beings to death without complaint under oath, without trial by jury, without opportunity to make defense, and without right of appeal. During the last 10 years, a new statute has been added to the unwritten law. This statute proclaims that for certain crimes or alleged crimes, no Negro shall be allowed a trial, that no white woman shall be compelled to charge an assault under oath or to submit any such charge to the investigation of a court of law. The result is that many men have been put to death whose innocence was afterward established. And today, under this reign of the unwritten law, no colored man, no matter what his reputation, is safe from lynching if a white woman, no matter her standing or motive, cares to charge him with insult or assault. It is considered a sufficient excuse and reasonable justification to put a prisoner to death under this unwritten law, for the frequently repeated charge that these lynching horrors are necessary to prevent crimes against women. The sentiment of this country has been appealed to in describing the isolated condition of white families in thickly populated Negro districts, and the charge is made that these homes are in as great danger as if they were surrounded by wild beasts. And the world has accepted this theory without let or hindrance. No matter that our laws presume every man innocent until he is proved guilty, no matter that it leaves a certain class of individuals completely at the mercy of another class, no matter that mobs make a force of the law and a mockery of justice, no matter that hundreds of boys are being hardened in crime and schooled in vice by the reputation of such scenes before their eyes. If a white woman declares herself insulted or assaulted, some life must pay the penalty. With all the horrors of the Spanish Inquisition and all the barbarism of the Middle Ages, the world looks on and says, "It is well." Not only are 200 men and women put to death annually on the average in this country by mobs, but these lives are taken with the greatest publicity. In many instances, the leading citizens aid and abet by their presence when they do not participate. And the leading journals inflame the public mind to the lynching point with scarehead articles and offers of rewards. Whenever a burning is advertised to take place, the railroads run excursions, photographs are taken, and the same jubilee is indulged in that characterized the public hangings of 100 years ago. There is, however, this difference. In those old days, the multitude that stood by was permitted only to guy or jeer. The 19th century lynching mob cuts off ears, toes, and fingers, strips off flesh, and distributes portions of the body as souvenirs among the crowds. If the leaders of the mobs are so minded, coal oil is poured over the body, and the victim is then roasted to death. This has been done in Texarkana and Paris, Texas, and Bardwell, Kentucky, and in Newman, Georgia. In Paris, the officers of the law delivered the prisoners to the mob. The mayor gave the school children a holiday, and the railroads ran excursion trains so that the people might see a human being burned to death. In Texarkana the year before, men and boys amused themselves by cutting off strips of flesh and thrusting knives into their helpless victim. At Newman, Georgia of the present year, the mob tried every conceivable torture to compel the victim to cry out and confess before they set fire to the faggots that burned him. But their trouble was all in vain. He never uttered a cry, and they could not make him confess. This condition of affairs were brutal enough and horrible enough if it were true that lynchings occurred only because of the commission of crimes against women, as is constantly declared by ministers, editors, lawyers, teachers, statesmen, and even by women themselves. They publish at every possible opportunity this excuse for lynching, hoping thereby not only to palliate their own crime, but at the same time to prove the Negro a moral monster and unworthy of the respect and sympathy of the civilized world. But this alleged reason adds to the deliberate injustice of the mob's work. Instead of lynchings being caused by assaults upon women, the statistics show that not 1/3 of the victims of lynchings are even charged with such crimes. Quite a number of the 1/3 alleged cases of assault that have been personally investigated by the writer have shown that there was no foundation in fact for the charges. Yet the claim is not made that there were no real culprits among them. The Negro has been too long associated with the white man not to have copied his vices as well as his virtues. But the Negro resents and utterly repudiates the effort to blacken his good name by asserting that assaults upon women are peculiar to his race. The Negro has suffered far more from the commission of this crime against the woman of his race by white men than the white race has ever suffered through his crimes. Very scant notice is taken of the matter when this is the condition of affairs. What becomes a crime deserving capital punishment when the tables are turned is a matter of small moment when the Negro woman is the accusing party. These are the words of Mrs. Ida B. Wells-Barnett. The article is entitled Lynch Law in America. It was published in January of 1900 in a publication called The Arena. If you've enjoyed this good literature reading, we do ask that you like, comment, share, and subscribe. This was a good literature reading by Teyuna Darris. Visit us online at www.goodliterature.org.